Hey everybody. So this is yeah, this is the much shorter summary of the surprise motion for summary judgment from Jen Abel that come down last night. I was not expecting it. I've seen a few others as well, like Little Girl Attorney, not actually Golden. I think it took us all by surprise, but a very, very pleasant surprise. So I did my longer video and I talked a lot, read through and commented quite a lot on it. And the first thing I did point out was I'm highly impressed by the legal drafting that went into that. It is a masterpiece and it is one of the best crafted legal filings we have from this case so far. It's a masterclass. It's genuinely a masterclass. It was very to the point. So the whole objective is to make Stephanie Jones conditionally liable for Blake Lively's fees and damages in the event that Blake Lively prevails over Jennifer Abel. So when we say conditional summary judgment, what that means is she's looking for the judge to make a conditional, like a like a decision, which then if Jen Abel loses or loses her trial, because obviously there's the lawsuit, separate lawsuit against Stephanie Jones, and Stephanie Jones has one against her. So if Jen Abel loses, then the condition would not be met, and then effectively the judge could reverse the decision. If Jen Abel wins at trial against Stephanie Jones, then then basically the judge's decision would stand if he does grant this, and I think he will. So that is the position. That's the position for all of this. That's what this basically means. So I want to go back over just a few points that I really liked about it. Just really, really quickly. So the first, yes, this first paragraph here, there's one that I wanted to talk about because people will invariably be saying, well, why has she not brought Van Zandt into this? She only mentions it here in this paragraph. And that is the right thing to do. It is not the right filing to make something about Van Zandt. The objective of this filing purely is to make Stephanie Jones liable for all of Lively's damages and fees in the event that Lively wins against Jen Abel. So Van Zandt does not overly play into that. It is a part of the story, absolutely, but it is a part of, I think, a bigger part of the main claims that Jennifer Abel has against Stephanie Jones and Jonesworks, and again as a defense against Stephanie Jones's claims against Jen Abel. So we're not going to see it here, but she does say, in breach of Jonesworks' contractual and fiduciary duties to the Wayfarer clients, Jonesworks Chief Executive Officer Stephanie Jones inexplicably and covertly advised Lively of the Wayfarer clients' public relations activities. Lively then caused her entity, Van Zandt, to commence a frivolous lawsuit in New York State against John Doe's devoid of any reference to the Wayfarer clients or Abel. Jonesworks participated in the hoax orchestrated by Lively by generously complying with a knowingly invalid subpoena from Van Zandt, i.e. Lively, which sought the Wayfarer clients and Abel's communications, and which any other recipient thereof would have moved to quash. Based upon these communications, Lively manufactured a claim against Abel for allegedly aiding and abetting retaliation when, in truth, Abel merely engaged in standard public relations. So what she is saying here, where Van Zandt does come into this, is Jen Abel is effectively saying, well, I wouldn't even be in this had all of this unethical stuff, this little, you know, backhanded deals between Lively and Jones not being taking place. And Stephanie Jones was complicit in that. She knew when she saw a subpoena from Van Zandt Inc. for the data that was on my work phone, my work issued phone, my data, Stephanie Jones knew fine well that there was no connection to Van Zandt. She knew it was Lively, and I would not be in this lawsuit but for her compliance with this known to be false and fraudulent subpoena. That is the relevance of Van Zandt, and that is where it needs to stop. And I'm glad she did, because it's not the right arena. This next paragraph, I loved this. The wording is beautiful. Abel's actions at issue herein were all undertaken as a Jonesworks employee within the scope of her employment, and were foreseeable by and known to Jonesworks. Therefore, under well-established New York law, Abel is entitled to common law indemnification from Jonesworks, regardless of whether Jones realized at the time Jones betrayed her then clients, the Wayfarer clients, that her unwavering alliance with Lively resulted in Jonesworks' own potential liability. And that is the important bit, because it doesn't matter if Jones was aware that this was going to happen as a result of her actions. It's really well crafted. I've made some marks a couple of more pages. Let's see. Oh, okay. So legal standard, right? This is just a little bit about the legal standard, just to pass out from all this information some relevant points. So, summary judgment is appropriate where the movement, which is Abel in this case, shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. In response to the non-moving party, so that's Jonesworks, the non-moving party must then set out specific facts showing a genuine issue of material fact for trial. So she's saying, well, all I did was my job. That's all I've ever done is my job. I was acting for, up until the 21st of August, 2024, I was employed and working solely for Jonesworks and at the direction of Jonesworks, for Jonesworks clients, i.e. Wayfarer. Jonesworks was aware that Wayfarer had also brought on Melissa Nathan and Tag. None of this was news. It wasn't that they brought on Melissa Nathan and Tag as an alternative to Jonesworks, right? Jonesworks is a PR company. Tag is a crisis PR company who, they deal with more specialized, PR issues. So they were to work alongside each other and complement each other. It is, although Stephanie Jones keeps sort of giving the impression that basically Jennifer Abel was effectively working for Melissa Nathan instead of Jonesworks, that is not true. The only response I could see Stephanie Jones making here in response to this is, no, she was doing other things. She was working for Melissa Nathan. She was working for, Jed Wallace. I don't know. Because he's not mentioned, his name does not even actually come up in this, Jed Wallace. There is, that's not going to wash at all. Because Stephanie Jones, in her own complaints and crisis PR, it wasn't the fact that, in her own complaints and motions to dismiss, it wasn't the fact that a crisis PR team was engaged. So that sounds like a normal thing, actually. It was that she didn't want Melissa Nathan specifically. She even recommended other crisis PR firms that Wayfarer could have engaged. So it wasn't the fact that Crisis PR was engaged at all. And Stephanie Jones herself said, well, I recommended other firms, but they went with this one and I'm not happy about it. So it's specifically her bone of contention is with Melissa Nathan. That is because I know from past sleuthing that that Stephanie Jones attempted to hire Melissa Nathan. She was all set to join Jonesworks, clearly come to her senses and bailed. So that is part of the reason that there is all this beef between Melissa Nathan and Stephanie Jones. So that is that. So the way Stephanie Jones spins it, oh well, Jennifer Abel, she was working with essentially for Melissa Nathan. No, it was kind of partnered with an outsourced service. The fact that they got on very well may have been sticking in the throat of Stephanie Jones, but that's her problem. Maybe something she needs to have some therapy for. Okay, so a genuine issue of material fact exists only when there is sufficient evidence favouring the non-moving party, such that a reasonable jury could return a verdict in its favour. So, this is basically setting the bar that, well, there's only going to be something, this only needs to go in front of a jury if there is an issue that is so contested that it needs a jury's determination. And it's not contested as in, like what we're seeing here, essentially. I did everything for Jonesworks from one side, and Jonesworks coming in saying, no, you didn't. Some of it you didn't do. Because Jonesworks can't deny that was under Jonesworks in a capacity as an employee for Jonesworks. I'm sure she'll try, but Stephanie Jones cannot deny that everything that Jennifer Abel did for Wayfarer over that relevant period, all Jen Abel acting on her own interests. That is ridiculous. She is saying that some of it went beyond. But in fairness to Abel, she brings out some great evidence that actually Stephanie Jones was very much in the know and in the thick of all of this, and actively participating in it even. And this then is quite important. A party may not rely on mere speculation or conjecture as to the true nature of the facts to overcome a motion for summary judgment. And I think that's arguably what we would call Stephanie Jones's allegations. They are speculation. No, well, yes, she was my employee. Yes, she was working for my clients doing what is essentially PR work, but she wasn't doing what I would ask her to do. She was acting off her own interest. That's speculation. Without some evidence to it, that is speculation, and that is not enough to overcome a motion for summary judgment. And that is why I think there is a very strong chance, 95%, I think I would give, 95% chance the judge will grant this. All right, so New York common law. And I love how they kind of set her up for this. Jen Abel, set up Stephanie Jones. So all the way through, Stephanie Jones has been arguing for New York law, right? So we obviously saw that the first employment contract was California law, and then the new contract that was sort of put in place the following year was New York law. All through her complaints, Stephanie Jones has argued for New York law. Now, Jen Abel is arguing that California applies. But what she is saying here is, whilst preserving all rights, and for the purpose of this motion only, that Jonesworks contends that New York law applies to Abel's common law indemnification claim. For purposes of this motion and reserving all rights with respect to her other claims being her main employment claims against Stephanie Jones. So, for the purposes of this motion and reserving all rights with respect to her other claims, Abel agrees. Where the parties agree that New York law controls, this is enough. This is sufficient to establish choice of law. So we should not get this long drawn out choice of law argument in front of the judge that we saw with Blake Lively and Jed Wallace across multiple courts. So, implied or common law indemnification recognizes that a person who in whole or in part, and that's important. So even if she says, I will have to reread that, but just to clarify that point, even like I just said a minute ago, Stephanie Jones cannot say that everything that Jen Abel did for Wayfarer around, the specified time up until her termination was all in her own interest and against Jonesworks instructions. At least some of that work would have been as an employee for Jonesworks clients. And this is where they've got her. So again, implied or common law indemnification recognizes that a person in whole or in part has discharged a duty which is owed by him, but which is between himself and another, should have been discharged by the other, is entitled to indemnity. So even if only part of the job that Jen Abel did was, as an employee of Jonesworks, then she is entitled to indemnity. That is the standard. Have I got anything else on this? No. I'm just going to say, this has very likely been, all the lawyers here are absolutely incredible, top-notch lawyers. But if this is what we're getting from the new counsel, Shapiro and Bat, then well worth every penny. Really, really good. I'm sure that both Friedman and Fritz and their firms are, they've contributed heavily towards this. So I don't want to say it's all these new lawyers, but it's impressive work. So this is the section 56.1 statement that was attached. I did go through it in my longer video, but this one paragraph I found quite compelling because, I'll read it first actually. So this is paragraph 110. In the August 14th, 2024 email chain, Jones provided the Wayfarer clients with Jonesworks' recommended strategy for dealing with the publicity crisis. So this is 1 week before Jen Abel was terminated, right? And Jonesworks is, literally offering suggestions and putting forward ideas on how to deal with specifically the crisis around the Blake Lively and the marketing of the film. So her strategy is basically, 1, flood the zone with positives, which is very similar to what Melissa Nathan put in her strategy. Flood the zones with positives, ensure that we promote positive narratives that media outlets cannot ignore. And because currently most stories are heavily biased towards Blake's perspective, it is crucial that we fight for every inch of every story. And 2, prepare alternative stories. Mobilize a robust network of supporters and third-party advocates ready to counter these narratives on deep background, as well as some on the record, making it clear that the claims being made are untrue and unfounded. So what Jen Abel is saying here is, look, judge, all right, if I am found liable for smearing Lively, Jones and Jonesworks are balls deep in it with me. but I was the employee and I was doing what she told me to. So you need to make her indemnify me. And I think she's going to win. I'm going to leave it there because we've obviously got the motions coming later as well from Lively and from Wayfarer. But if this is a taste of what we're going to get, I am excited. So I will do my videos in this format, a longer one, then a much shorter summary of some relevant, important points I like, a bit of commentary. I will use the same thumbnail, except the shorter one will have summary at the start. And yeah, it will probably take a day or two to get through it all. All right. Thank you for listening. Catch you later.